Hi, everyone. My name is Karina Chow, and I'm on the Government Affairs and Public Policy team at Google. I'd like to extend a warm welcome to our guest today, Ryan Abbott. Ryan's a professor with joint appointments at the University of Surrey's School of Law in the UK and the UCLA School of Medicine in the US. Ryan has an MD, a JD, a PhD, an MTOM, and apparently also a ton of student debt. Something that is not in his bio online is that Ryan was previously a prison doctor, so he has firsthand experience when he writes about the impact of AI in medicine as well as in criminal law. He also met his wife while he was a prison doctor, but that's another story. In addition to his many professional experiences, Ryan is a dad to 3 daughters, 2 of whom were born while writing his book, The Reasonable Robot. He's clearly a busy man, and we're very lucky to have him here with us today to tell us more about the book. There will be plenty of time for audience Q&A, so as you have questions, please add them into the live chat. I'll start with some initial questions for Ryan, and then we'll go to the live Q&A. Hey, Ryan.
Hi, thanks so much for having me.
Great to have you. Let's start with a short description of your book. What is The Reasonable Robot about, and what brought you to write it?
Well, the book is engaging with the idea that AI is starting to step into the shoes of people and do the sorts of things that only people used to do. But when it does this, it's subject to a whole different host of legal rules, and these sometimes have unintentional and negative outcomes. And the book is looking at the different areas of the law where AI and people are starting to behave in ways that are more interchangeable, and how these different legal systems could be improved if we had similar legal standards for both.
Yeah, that makes a lot of sense. And you write about something in your book called the principle of AI legal neutrality. What is this, and why do you think it's important?
So businesses and governments and industry groups are thinking about how to regulate AI now, and there's been a lot of work in the past few years to articulate principles of regulation for AI, which is a good start before diving down into kind of deep specific regulations of exactly how people should do things. And a lot of these have focused on things like accountability and human agency and transparency. And I'm arguing in this book that one of the principles that hasn't yet been articulated is that we want similar legal standards to appear to behavior, to apply to behavior by AI and behavior by people, and that this will help the law to better achieve its underlying goals. So you asked also how I came to start writing about this. In 2014, I was doing some multitasking right after working as a prison doctor, where I was teaching patent law, and in particular, the law of inventorship and what makes a person an inventor, and also doing some work with intellectual property for life science companies. And was looking at vendors essentially advertising they were using AI in drug discovery to model drug-drug interaction or mine patient data sets for new indications for existing drugs, or find antibodies for antigens from big libraries. And it was interesting that looking at this, you would have a company giving an AI company a problem. You would have one team building an AI, but not necessarily knowing what problem it would solve. And then another person just sort of setting the AI on the data and coming up with an output, the value of which might be pretty obvious. And I was wondering, well, gee, that's interesting, because that sort of activity, when a person does it, makes them an inventor. And here we have an AI doing it. And I wonder if anyone's ever really thought about that. And it turned out that people had been thinking about it for decades, but saying, well, you really wouldn't need a patent if an AI comes up with an invention, because machines don't care about patents. And that's true, but it ignores the point that the people who make, use, and own AI do care about patents. And if machines come to be a significant source of invention, or even a better source of invention than people in some areas, you want to be able to incentivize that sort of behavior, namely encouraging people or companies like Google to build inventive machines and generate more social value. And so the law on this really isn't terribly clear, and there really doesn't seem to be much law on it, at least a year ago. There are laws that basically say for an invention, you have to have a human inventor, but those laws date decades back to when people wanted to make sure that even though companies own most patents, human inventors were at least acknowledged. But it doesn't really say about what you would do if you didn't have a person inventing something, except if you read it literally, well, there has to be a person. So you wouldn't get a patent on something that an AI essentially made. And I think that's not the right outcome, because you want to encourage innovation, whether from a person or a machine, because both ways you get more social benefit. Both of these sorts of activities should be protected. And I think, whether a person or a machine comes up with something, it should be eligible for patent protection. And so, that is the first area that I considered this idea of AI legal neutrality, and the idea that you would have similar legal regimes for things done by people and things done by machines. And the book is kind of opening this up and looking at a few other areas where that also applies.
That's fascinating. Let's dig into that a little bit. From what you've seen, kind of the patent case and inventors, what do you think is the solution, right? You said you think this idea of AI legal neutrality should apply. Specifically, should it be exactly the same, whether it is a human or a machine inventor, or do you see kind of nuances and details on the implementation?
Right. So I think that similar sort of legal regimes will be helpful, but not identical. An AI behaves like a person, but it isn't like a person. It doesn't deserve rights or have, moral rights. It can't own property. It wouldn't really make sense to give it property. So some things should be different. Essentially, I think as we are looking at how AI is going to disrupt our system of laws and regulations, and how to build systems of laws and regulations to harness social benefit from AI, we need to kind of turn back to, well, what is the law trying to accomplish? And in patent law, it's trying to do a few things, but mainly to encourage people to innovate, because innovation often takes a lot of investment, and building inventive machines often takes a lot of investment. And so I think kind of the key insight with this is, and there's really a broad international dialogue about this issue right now, is, how do we make patent law so that we get people innovating? And I think that the way to do that is just to say, well, when you have a patentable invention, it really shouldn't matter where it originates from, whether a person, a machine did it, whether they jointly did it. The owner of the AI should own any AI-generated inventions, and this will increase the value of inventive machines and their output, and encourage companies to build inventive AI, which is not only already relevant for things where AI may have an advantage over people, like finding patterns in hundreds of millions of patient records for new uses of drugs or things like that. But in 10 or 20 years, AI may be a better means of generating invention in some areas than people. So it's particularly critical to have those rules now.
Mm-hmm. Yeah, and I understand that you're putting this into practice with a legal test case. Could you elaborate a little bit more on that?
So as I got interested on this and started speaking about it, it went from, in 2014, people thinking, well, that's kind of interesting, to now when I speak about it, companies coming up after and saying, geez, this is an issue we're kind of concerned about. And in fact, Siemens announced last year that they had multiple patentable inventions that they wanted to file on, but couldn't identify a human inventor. And indeed, in the United States, it is a criminal act to misrepresent yourself as a patent inventor on an application. So you can't just put anyone, although kind of the earlier people who have done this said their patent attorney said to list themselves. But as speaking about this, it became clear that this was an unresolved issue, that people were thinking about it, that there wasn't really any law on this, and probably not likely to be any law, because a company disclosing that something was made by an AI would be likely to lose their protection on it because of these requirements for individual inventors. And so I teamed up with a group of patent attorneys who were interested in this. We filed a legal test case. We filed it back in 2019 in the US, the UK, and in Europe. And we didn't disclose that there was an AI inventor until the UK and the EPO had already looked at the application, decided it was patentable, and then we said, well, surprise, what do you want to do about this? There's not an inventor. So far, all three of those applications have gotten rejected, but they are all being appealed right now. And in fact, next week, this is getting appealed in the UK High Court. The applications are also pending in a whole bunch of other jurisdictions: China, Japan, South Korea, India, Israel, Canada. And we'll see different jurisdictions are thinking about how they want to handle AI-generated inventions, and I wouldn't be surprised to see some of them come out differently on it.
Interesting. For the 3 rejections, did they give the same answers for why, or kind of is there like a variety of thought?
Well, they were all rejected for procedural reasons, because when you submit an application, you have to disclose an inventor, or in the UK and the EPO, you get 18 months to disclose an inventor, and we didn't disclose one, or we did disclose one, we disclosed the machine as the inventor. And even though inventors have the first rights to their applications, and even though they're commonly assigned to employers, we listed the AI because we wanted first to be clear about how the invention came about. And also, we didn't think it was right that someone should just be able to put their name to an invention they didn't create. It would allow people to take false credit for things and undermine the value of invention. All three of those jurisdictions said essentially we didn't comply with the formalities requirements to have a human inventor. And so we are appealing those, because even though they are formalities rejections, ultimately it's a deeply substantive question about whether you can protect this sort of activity at all. And not just on patents, really, but all forms of intellectual property. And indeed, machines have been much more active at generating poems and stories and songs and movies. You know, it's a lot easier to make a creative artistic work than it is to make a patentable work. You know, maybe harder to make a good artistic work. But in any case, the bar to making something new creatively is really very low under the law. So machines have been doing that for a long time. And the UK has a standard that allows a copyrightable work made by a machine to be protected. It belongs to the producer of the work. The US, on the other hand, prohibits that sort of thing. And there was an interesting case a few years ago called the monkey selfies case, which involved a crested macaque named Naruto, which took a picture of itself. The owner of the camera tried to exploit the image, and eventually the US Copyright Office said, no one can own a picture taken by a monkey. Well, PETA sued the photographer a few years later, arguing that the monkey owned the photograph and that the photographer was infringing it by publishing it. And that case ultimately got dismissed, but on standing, because the monkey didn't have standing to sue under the Copyright Act. But there's really never been any case challenging the U.S. Copyright Office human authorship requirement, and I think there's a need for both the courts and legislators to get more engaged on the issue.
Wow. Yeah. And so where do you see this going, kind of with the appeals, the other countries? What's the direction of travel?
Well, part of the purpose of the cases was to raise awareness of this issue and stimulate kind of a broad multi-stakeholder discussion. And I think in that sense, it has been phenomenally successful beyond, I was thinking this might be a footnote in a textbook somewhere, but there really has been a lot of interest in the case. Ultimately for policy matters like this, there's certainly an argument that politicians or legislators are better positioned than judges to weigh stakeholder input and come up with deliberative policies. And the U.S. Patent and Trademark Office recently requested calls for consultations on these issues. And the World Intellectual Property Organization just today had a second conversation on AI and IP. So there's a lot of discussion about it. For the appeals, though, we're also hoping courts will recognize that these laws were not designed to prohibit protection of AI-generated inventions and to dynamically interpret existing statutes to permit this sort of thing.
Mm-hmm. Yeah, so in the book, you write about IP. You also write about, the importance of AI legal neutrality with respect to torts, tax, and criminal law. How did you come up with these areas as kind of the important ones to focus on?
Well, I think they touch on some of the key issues challenging AI regulation right now. And they were in areas of personal interest to me also, and also areas where I had colleagues who were active in the area, and some of these were kind of jointly worked on together. With torts, for example, self-driving cars are often held up as kind of a main regulatory case study. And often it's in the context of people freaking out that, well, we're going to have these self-driving cars on the road, and oh my God, what will happen when someone's hit by it? It'll be a disaster. Who's going to be liable for it? Nothing's going to be liable. I think that's really not the right focus on something like torts, because self-driving cars are essentially all commercial products, and manufacturers and suppliers are liable for commercial products. If Google has a self-driving car that hits someone, Google's going to be liable for it. And indeed, in the accidents that have already happened with AVs, I think those have largely kind of quickly resolved. It's really a lot less an issue of payment. It's more an issue of, again, to me, having separate legal standards. So With a person driving a car, we hold them to a negligence standard, which says we only hold you liable for accidents if a reasonable person wouldn't have caused the accident. But with a self-driving car, because it's a commercial product, it has a strict liability standard, which is to say any accident that this car causes due to a defect or defective manufacturing, it will just be liable for, which is a higher liability standard. And it's generally good to have higher liability standards for products because it encourages manufacturers to fix mistakes or to fix defects in them. But it's not good if the product actually is safer than the alternative, which would be human drivers. And humans are terrible drivers, causing about 94% of accidents due to human errors and about 40,000 fatalities in the US alone from driving. So if a self-driving car is safer than a person, you wouldn't really want to hold it to a stronger liability standard because that would discourage it being used. Although ultimately, because self-driving cars are just going to keep improving, it's a little less important what liability standards we hold them to because there's all sorts of non-liability reasons for them to get safer. You know, people want cars that are safe regardless of tort liability. I think really the more interesting issue with them is that self-driving cars are going to be almost perfectly safe someday, and people are going to still be terrible drivers. And really maybe what this suggests is that we're holding people to the wrong standard, or we will be when we hold them to that of a reasonable person. And we should be holding them to the standard of a reasonable self-driving car. And so if I'm out late at night and I, can't stop an accident, if a self-driving car wouldn't have caused the same accident, I should probably be liable for it. We, could do what Elon Musk has suggested and say, all right, we're going to ban human drivers because self-driving cars are safer. But that really infringes on human autonomy and freedom. And so a better way of dealing with this might be to say, all right, well, you're allowed to drive, but if you cause an accident that a self-driving car wouldn't have caused, you're going to be liable for it. Assuming, of course, it's practical to have everyone behind self-driving cars, if they cost $1 million each, you couldn't do that. But it's not just driving, but a lot of things that AI is going to do and probably do a lot safer than people. And it's also interesting to think about it in the practice of medicine, where a number of companies are working on automating aspects of medical care. And really in just a few areas is AI looking like it might be a little bit better than a doctor, but probably again in 10 years, there's going to be some aspects of medical care or large aspects of radiology where an AI outperforms a person. And it's not clear to me that you're going to want people doing that sort of work, or even that it will be ethical for physicians to do that sort of work when an AI can do a much better job.
And where do you think about, you brought up two cases, medical case and self-driving car case, when should that transition in the law happen? At what point of development where, cars are maybe mostly self-driving, is that when you start to think about changing the standards? Like, how do you think about that?
Well, it's a good question. I don't know there's a bright line to it. We don't require people to have the latest model of car, even though it's safer than cars that were made decades ago. On the other hand, there are things that we do insist on cars, like seatbelts and airbags and kind of, standard safety devices. So, for something like that, I think the right line is that the reasonable sort of thing to do is to automate. If self-driving cars are not within the financial means of an average person, or it's not reasonable for someone to acquire a self-driving car, there's not enough of them, you couldn't hold someone to that. But a lot of standards under the law do not have these hard and fast rules like it has to cost less than $20,000. It bases the standards on norms of human behavior like reasonableness. And one of the things the book is kind of getting at is you have standards of law based on reasonableness, but it will be AI behaving in these sorts of ways where we haven't really figured out how to apply standards of human behavior to AI and vice versa.
So things that we've seen kind of happen often in this technology development cycle is, technology will continue to move and advance, and policies and law and frameworks tend to be kind of lagging behind in terms of development. What are your thoughts around kind of, the AI legal neutrality as it applies to torts? Do you think that is going to be able to be something, that societies can get in time for developments, or do you see this kind of as an important thing to address, but it'll likely happen kind of a bit behind schedule?
Well, whether it actually happens or not is a whole nother question, but it is certainly something that people could decide to address now, and something that I think both industry and government have to really be proactive about, because on the one hand, there's a sense that regulators and legislators don't really know what they're talking about. You should just kind of let industry do its thing. It'll mostly take care of itself. And if you look at the history of regulating industries like that, a number of bad things tend to happen because industries do not have the same sort of incentives to promote public good as governments do. And they can't be draconian technological measures that lock in technology and prohibit progress. But you do need to have a legal framework that ensures that in whatever technological area AI develops, that it's doing so in a socially beneficial sort of way. And so, this starts with things like having principles of beneficence in AI development, but then has to drill down into standard setting organizations and, US automobile regulatory agencies essentially putting in binding requirements where when you have, technologies that are dramatically safer or improved, that you encourage their adoption. Or, and it's not just safety, it's all sorts of things, lots of concerns about privacy, for example. And you've seen in the past few years that after, for a long time taking a hands-off approach, both Europe and, say, California have really led the way in promoting protections for consumer privacy, because every business is not going to be a good actor, and the law is really needed to set some minimal standards of behavior.
Mm-hmm. Yeah, so speaking of that, let's kind of move on to another area that you address, which is criminal law. How do you think AI legal neutrality should apply? Why should it apply to criminal law?
Well, criminal law is a really interesting area, at least to think about theoretically. On the one hand, as we are moving towards technologies that are out there kind of more autonomously doing socially good things like inventing and generating wealth and driving people around, we're likely to have at least some AI that's out there autonomously doing bad sorts of things in ways that aren't necessarily reducible to the wrongful acts of people doing things. And so there's a legitimate question about how do we deal with this sort of thing. And, in the same sense that the book advocates for protecting inventions by machines or having a more neutral tax code to level the playing field for people and machines, it might make sense to think about punishing an artificial intelligence with criminal law. This is the sort of thing that people are writing about and thinking about. And so the book kind of looks at that and whether it makes sense and whether it would be a good idea. And on the one hand, the law is often and usually concerned with promoting or discouraging certain sorts of behavior. So incentivizing innovation, promoting safety. And on one hand, criminal law is also about that. It's about discouraging antisocial sorts of behavior. On the other hand, even though the law usually doesn't care that much about what makes someone do something, it really does tend to do that in criminal law, where not only do you usually have to cause some sort of harm, but you have to have some sort of wrongful mental state, an intent to cause harm. And it really isn't clear that an AI could ever have an intent to do anything because it's just executing programming. So in that sense, it just kind of seems confused, like hitting your computer when it crashes. But legally, the law does already hold artificial persons in the form of corporations criminally liable for wrongs that have been caused in the corporation's name. And the law does also not always require wrongful intent. So you can have strict liability crimes like selling alcohol to a minor, even if you reasonably believed them to be an adult and you didn't intend to sell alcohol to a minor. A corporation can be held criminally liable even without a wrongful mental state, and even sometimes based on a failure to act when there's a duty to act. So one of the things the book goes through and considers is, well, would it ever make sense to hold an AI criminally liable? And is there some sort of analogy to a mental state that could coherently apply to an AI? And one of the things the book argues is that, well, you could have some benefits from criminal punishment of AI, both if this had an impact on the behavior of people making, using, and owning AI, because it would result in the destruction of an AI or a fine levied against them. victims of AI crime would see their rights vindicated. On the other hand, it would be a pretty dramatic legal shift. And even though one could theoretically do it, there doesn't seem to be a whole lot of good reason to do it when there's probably better solutions to this sort of thing, like holding people civilly liable for irresponsibly making AI, or to the extent that you really can't associate AI behavior with a person, maybe a mandatory insurance scheme like a tax on AI that provides a victim compensation fund for when there's AI out running over people on purpose. So even though the book advocates in tending not to distinguish between AI and human behavior, criminal law tends to come out a bit differently than that. But perhaps 10 or 20 years in the future, when we have really bad AI, we'll have to take another look at that.
Fascinating. You talked a little bit about kind of, ensuring the benefits of AI are shared by all. And I will say that's something that, we have a lot of discussions about, how do you make sure that with all of these advances that are coming out, almost all of society or all of society is really able to gain those benefits rather than just a small fraction. So you write a little bit about that in your book as well, with respect to AI legal neutrality and taxes, distribution of wealth. What does a better tax system look like in this new world with automation?
Well, I think that's a great question. And I think AI poses some really interesting challenges to tax that people haven't really thought about. And Bill Gates suggested a few years ago, we ought to tax robots to slow down innovation, to reduce social disruption. And I think there's a whole nother better reason to do it, which is that AI and people can do the same sorts of things now, but are subject to different tax rules about this. So a cashier at McDonald's and an automated teller, both more or less are doing the same sort of thing, but McDonald's and the employee both have to pay payroll taxes. So McDonald's has to pay an extra, 10-something%, depending on the country that they're in, to have a human being do the same job as a machine. And what that does is you have tax policy driving this time automation, because reducing employees and including machines is going to reduce a company's tax liability. So you have a kind of artificially unlevel playing field from taxes. And the other kind of critical, surprising things the tax law does is automation reduces tax revenue. Because in the United States, about 90% of federal tax revenue comes from payroll and income taxes, and a very small percent from corporate taxes. And so when McDonald's automates, the government loses all of the income taxes the employee would have paid, all of the payroll taxes on the employee. And even if the AI makes McDonald's slightly more profitable, which it may or may not do, this translates to a very small comparative amount of tax revenue. Given that kind of the major solutions to a possible coming major wave of automation are to retrain employees and invest in education systems, or to provide more social benefits, or in the event of genuinely widespread automation, a universal basic income, the government's going to need funding for that. And that's going to be even harder to do if we have widespread automation. More fundamentally, as we're taking a step back and thinking about how automation is going to alter tax policies, it gives us a chance to kind of reflect on our current tax policies and the values they have. And the United States has a particularly unprogressive tax system. And given that AI is going to generate probably a huge amount of wealth, but that it's going to be narrowly concentrated, this is an opportunity for us to think that, well, maybe we want a more progressive tax system, and maybe we want to encourage automation, encourage the generation of wealth, but share that wealth a bit more broadly. And if you decided you wanted to do that, there'd be a lot of ways to do it. I argue in the book that we should get rid of payroll taxes because it would allow people and machines to compete more fairly, and that we could make up this revenue through property taxes, sales taxes, progressive income taxes, or more ambitiously by increasing capital tax rates. Historically, economists have been against increasing capital tax rates and in favor of income rates, because people think, well, if you raise capital taxes, money will leave, your jurisdiction. But historically, it's not really clear that that is held up, and that capital does flow into higher tax jurisdictions because they're better investment opportunities.
Awesome. Well, I'm seeing several questions on the live chat. Let's start with the first one from Nathan. One area where the market seems to discriminate is where people are fine being seen in public by anyone's bare eyes, yet they become uncomfortable with cameras. Any thoughts on this?
No, that's a great question. And I think AI changes the dynamic in this area because, yes, people are generally okay with the sense that, well, I'm in a public area. I realize that people can observe what I'm doing. But now that you have a world full of cameras and AI, it is possible to permanently record and parse out every single sort of thing one does in public in a way that was never not possible in an AI-generated world. So I think that what that does is not so much kind of suggest a different approach to people in AI, but think of a different approach to our privacy laws and kind of government intervention in privacy, because there is already a tension or a dynamic between the government's rights to monitor its citizens and someone's rights to be free of privacy and unreasonable searches, and that maybe this is kind of a reason for us to reconfigure just what extent someone has a right to privacy in a public space.
You mentioned earlier the California law. Is there a jurisdiction that you think is doing a good job with respect to privacy laws?
Well, and one of your questions kind of when we were speaking earlier was, how are different jurisdictions addressing these sorts of things? And I do think that there are a few best practices that all jurisdictions could adopt. But on the other hand, different rules are probably better for some sorts of jurisdictions. So for AI exporting countries like the United States and China and the UK, protecting AI generated inventions is going to be particularly important. For countries that really don't have any domestic AI capability, it's really not going to be so important. Well, similarly, people do have different values around things like privacy versus security versus commercialization of new products. So you see very different approaches in somewhere like China, where you have a very kind of pro-commerce, laissez-faire regulation, strong government intervention in technology, versus somewhere like Europe, where they're very skeptical of government intervention and where they have much more emphasis on privacy rights. And so, there where you have the GDPR and you have kind of a sense, although still controversial, of a person owning their personal data, right? I don't know that there's necessarily a absolutist right or wrong to that, but I think that you do see different communities wanting their own rules that reflect their values on these underlying issues.
Yep. Next question is from Josh. How do you successfully argue for patentable AI work and regulation to politicians and judges who don't often have a nuanced understanding of what AI is and does?
Lobbyists, but one could make that argument about just about any judge or politician that, they don't understand complex technical areas as well as engineers and industry does. And so I think kind of there's two answers to it. One is that this is why it's important to have multi-stakeholder dialogue, and why I think it's good that the USPTO and WIPO are doing what they're doing, because government certainly doesn't know everything. Industry certainly doesn't know everything. There's critical input needed from nonprofits and from individual consumers and from groups on the other end of things. And, it is a iterative and educational process. And, to the extent that, a lot of this is higher level principle binding, regulatory agencies may be in some instances kind of better to hash out the details of how some of these should apply in particular areas. But I think there's a role for both agencies, courts, and legislatures in this, and that all have something of value.
So Victor brings up the next point in question. AI has the ability to amplify and exacerbate hidden biases and prejudices. Do you think we're at a sufficiently social, racial equity point in AI to permit lenient AI policy?
A great question, and I have two answers to it. One is that I wouldn't say that I'm advocating for a lenient AI policy. I think that there is a lot of evidence now, and still an emerging evidence base, that AI can behave in racially biased ways, that this is a serious problem, and that it's a problem that people need to be aware of and addressing. My point is more, and it is interesting with what's going on socially in the United States right now, that that there's sort of a separate standard for AI behaving in racially biased ways and people behaving in racially biased ways. And it is not necessarily the case that when AI does this sort of thing, people haven't been doing it. In fact, if anything, it's probably AI learning from historically biased data and perpetrating what's been happening historically. And as we're looking at how to fix the problem of racial bias, I think it may end up being a lot easier to fix that sort of thing in a machine than it is with a person. Because you can tell a judge or a police officer, you are not allowed to discriminate in judgments. And of course, a judge will say, well, yes, of course. And yet they still do. And it's very difficult to determine why a judge, made a particular criminal sentencing. You can look at it statistically, but a judge can always, explain what they were doing on some other basis. I think a machine is probably likely in some cases to be more transparent about what it's doing. And it's going to be a lot easier to overwrite rules that are inappropriate or create new rules to offset racial bias.
So the next question is from Zach. He speaks to both kind of the point you were making earlier around IP, as well as point we were discussing about how to make sure benefits are appreciated by all. So he asks, would granting AI's owners the patents lead to an exaggeration of the winner-take-all trend? Meaning the inventor of the first good AI in a field, likely a large company, gets all of the benefits.
Well, I think there's, two possible ways this could go. One is, for better or worse, most patents are owned by companies. Most patents are owned by large entities. And so I think there is a significant extent to which the IP system largely does financially flow primarily to the benefit of a few companies like Google. And to the extent that it is companies like Google that will be kind of at the forefront of building inventive machines, then yes, the benefits are going to flow predominantly to a few characters like that. On the other hand, it is also possible that it won't turn out that way. So the inventive machine underlying our applications, Dabus, was invented by Stephen Thaler at Imagination Engines, and that is a small business out in Missouri. So it is not all things being done by large companies, and it may be in the future that we democratize AI. And to the extent that we end up in a world where only Google and IBM and Amazon own inventive machines and everyone else is just sort of the passive recipients of this, I think that is something we're going to have to deal with, and that this is part of our discussions about competition law and how to ensure fair competition and really a level playing field for anyone coming along. But also, kind of in thinking of that future reality, one of the other interesting things about inventive machines and intellectual property is that the benchmark for granting a patent is based on your sort of average researcher, a skilled person in the field. And as inventive machines don't just become kind of one way that people innovate, but kind of a core part of research and development, this will also raise the standard for granting a patent. And so when all of the researchers at Google are kind of working together with inventive machines, it will be harder and harder to get a patent. And this may result in fewer patents ultimately being granted and more easy innovation that happens without the need for significant investment and without as much need for the patent system kind of at that future point in time.
So Victor has a follow-up point. He says, you stated that AI does not have intent. I disagree. The creators of the machine learning models provided it and who provided it data have prejudices and biases. Their intent is in the model's actions. So maybe, Ryan, you could comment a little bit about how you think about it and how should the creators have kind of responsibility as well.
Well, I certainly agree with that. And also the idea that in almost all instances in most of these things, an AI is essentially a tool that does what it's programmed to do and does what it's told. And to the extent that someone is really developing an AI specifically to invent something, to the extent that one is developing an AI to cause harm, I agree that the intent of the developer is really the intent that's made. So if I pick up my laptop and hit someone in the head with it, the computer hasn't committed a crime, I have. But as you have and will probably more in the future have AI that is, built by teams in open source sorts of ways, in ways that are not necessarily as predictable to even the people programming it through machine learning, or you have someone programming machines to do things, but then other parties, modifying and then going on to use them. I think it will not always be the case that you have someone whose intent is directly transferable to what a machine is doing. And this is very much kind of what is at the core of the concept of corporate criminal liability, because some people think, well, you don't really ever need to hold a corporation criminally liable because really there's always someone at the corporation who did that bad thing, and why not just hold that person liable? But many criminal law theorists think that, well, no, when you get into a corporation and you have an organizational structure, it's not always possible to look back and say, no, the corporation's bad thing was really this one bad thing this person did. There's groupthink, there's kind of synergistically small bad things that people do. You don't want to invasively delve into every single act a corporation has done because it would be too costly and not practical and criminalize very small things potentially. And so we have this legal fiction that, what this person has done, which feeds into this company, is what made this wrong thing. And similarly with AI, I don't agree that all the time someone who's building a machine learning algorithm, an algorithm based on machine learning necessarily intends for it to do everything it's going to come up with. Maybe generally in a sort of way, but not necessarily all the time. And yes, in crime especially, I think we're not there yet, but perhaps moving in that direction.
So following on that point, there's kind of a conversation happening in the live comments. We talked a little bit about bias. Obviously, sometimes unfair bias does come from training data. There's also a lot of other kind of places in the technology development pipeline. So it could be, in the model. It could be in the implementation of the model or application in product. All of these different pieces, which are oftentimes governed by sometimes the same, but sometimes different people or even different players and organizations. How do you think the law should think about these different aspects of places where both good as well as error can be introduced?
Well, no, I think that's exactly right. And I think that essentially answers the last question also, which is, yes, sometimes it's just one person with their model that they've trained and their algorithm does the thing that they've wanted it to do. But other times you have really this collaborative process. And I think the right way to think about it in these cases is really to consider the AI as an autonomous entity. The same sort of way that in 1997, when Deep Blue beat Garry Kasparov at chess, it wasn't really the programmers playing against Kasparov, and even if they were sitting there as a team, they would have lost terribly. They really all contributed something to an autonomous entity that has the ability to go out and behave the same way that a person would. And for us on the legal end of things to think about what sort of rules and regulations will encourage the people making, building, and using machines to make machines that behave in socially beneficial sorts of ways, right? Which are reducing antisocial behavior, promoting invention, promoting safety, distributive sharing of wealth, and that, that's the appropriate framework for it.
All right, the next question comes from Dan. And Ryan, you've lived in a lot of different countries. Are there certain countries or jurisdictions that you see as particularly progressive or astute in their kind of actions and policies and work towards legal standards for AI?
Yeah, well, I think some are definitely leading ahead. I think the United States has kind of been a bit off and on with it. I think the UK has maintained kind of a persistent interest in this. So, development of AI and of legal standards and of ethical standards are a key part of, government initiatives in the UK. The government is kind of providing substantial support through the Alan Turing Institute and through other, government or semi-governmental organizations to work on these issues. They promoted stakeholder dialogue. They've had consultative processes with their legislators. So I think the UK is kind of a good example of that. But, also China and the US and the EU have all announced initiatives to work on AI and come up with new policies. And I think we are moving from a stage in which people are agreeing on these kind of generic principles of regulation that most people can agree with, and really now needing to get into the nuts and bolts of, well, how to regulate in these particular areas. And I haven't seen a lot of jurisdictions that have really taken the lead on that. But I do think that the UK has had some kind of very good steps so far in developing principles and legislative buy-in.
Awesome. Next question from Zach. Do you think that AIs will have a significant role to play themselves in creating or writing new legislation and legal frameworks?
Probably only drafting templates for which people work off at this stage. But moving forward further in time, these are harder sorts of activities for AI, obviously, to think in more open sorts of ways and develop strategies. But it may well be in the future that, an AI does a better job of analyzing social problems and generating appropriate strategies for it. In the sense that technological optimists think that we're headed for artificial general intelligence and that AI is going to be able to do anything a person could do intellectually, and then, shortly thereafter do a much better job than anyone could do thinking about it. You might want AI in a position of making policy, or certainly at least suggesting policy. That's one of the scarier areas of thinking about taking people out of the loop. It's a lot easier to think about taking someone out of the loop when they're driving a car or probably even practicing medicine than when you are, making life or death decisions in the military or, passing criminal judgments or setting policy. But a couple of years ago, I think that there was a poll in the UK that said that, close to a majority of the UK public would be happy to have an AI running the country, which I think is a very scary poll considering the state of AI at the current time, and really speaks to a lack of general confidence in legislators. So I'm not entirely sure what to make of the poll, but certainly in the future, at least coming up with suggested strategies and working on it, at least in the short term in an augmented sort of way with people.
So on that idea of kind of where AI is and maybe where it's heading, MJ asks a question: can you speak to how, if at all, legal assumptions and goals might change as AI moves towards superintelligence?
Well, I think it changes very dramatically, and that is one of the things the book considers, right? If you have an AI that can do really anything a person can do intellectually and then quickly becomes much better than a person, well, there's really not going to be that much for people to do. And maybe there will be some roles that we really just want to say, we don't want a machine, we don't want killer robots, we don't want robot judges, we don't want robot politicians. But there's only so many judges and politicians and soldiers in the world. And that means for the rest of us, like law professors and lawyers, that is really going to dramatically change society and the laws that govern it. And some people think about this as kind of a dysphoric future in which people have lost all meaning and don't know what to do with themselves. I think that this is something that the law does want to encourage because it's going to result in a lot of social good. If we can make AI that is going to do a better job of practicing medicine than a doctor, that is something that will be good for patients and ultimately something that will be good for human doctors, because if you were practicing then, it would no longer be to help people. It would just be to get in the way of an AI that could do a better job. And that really isn't kind of an appropriate way to find meaning. So, it may change the way that people think about finding meaning in what they do in their life. And, ultimately in a way that results in us having a nearly unlimited amount of wealth and, much better health and, hopefully a much fairer distributive system. And I think that the role of the law in that should be to encourage development of AI taking over in these sorts of areas when it does a better job than people, to provide for more social welfare.
All right. Next question is from Priscilla. If AI should be given patents, why isn't a microscope credited with finding microbes? You can say that the programmers of Deep Blue can't play chess, but microbiologists could never work on their own.
Right. And well, to be clear, I don't think the AI should get a patent, but the owner of the AI should get a patent. And I think that this is the distinction between an AI being a tool and an AI being autonomous. And this is both an interesting legal and philosophical question about what autonomy is and what it means to be an inventor. But to invent something, it isn't necessarily the case that it isn't the case that you would have to have an AI that's artificial general intelligence or an AI that thinks like a person. All that you would really necessarily have to have is a patentable output without a human being who met the test of inventorship. I mean, that would be an AI generated invention. And a tool would never do that. You could not have a microscope that would by itself analyze data, promote patentable output, and identify the value of the output. Now, there are inventions that no one really invents, that they just discover. So Alexander Fleming, famously discovered penicillin from, looking at bacterial cultures and having an insight on it. And sometimes, inventions are where they're waiting for people to discover them, but it still requires inventive skill on the part of a person. And so if I'm an insurance company and I, have DeepMind come in, look at 500 million patient records and say, hey, look, Viagra also treats male pattern hair loss. There's really no inventive skill in someone figuring out, wow, we're going to be rich from this. Let's file a patent on it, right? And you don't get that through a microscope.
Yeah, so I think on that, you talk a little bit about invention. Earlier, you were talking about, the role of AI in medicine, self-driving cars, others. Megan asks, what do you think about protecting spheres of human agency? Do we actually want robot soldiers, judges, police officers, doctors, drivers, etc.?
Definitely drivers and doctors. And I'm not sure that we do want robot soldiers, judges, and police officers. But on the other hand, I'm not entirely sure we don't want them either. Particularly with what's going on right now, there are a lot of concerns about people engaging in bad behavior in positions of authority. And at least some of that might be mitigated by AI. For example, AI being responsible for issuing traffic tickets in an automated fashion rather than having police officers pull people over and having those sorts of conflicts. Killer robots may be terrible because you have machines making life or death decisions without human morality or common sense. On the other hand, AI might also be more restrained than human soldiers, particularly because it is not so incentivized by its own existence, and may do a better job of complying with rules of war. So, we're certainly not there now. I don't know if we'll ever want to be there in the future, but I also don't know that it's as clear cut as some people make it out to be.
So let's end with one last question, Ryan. Your book seems to buy into this concept of the singularity, the idea that machines will someday dramatically outperform people in just about every area. Do you see this as a good thing? Do you see this as a bad thing? What should people kind of do about that? And what are people going to do in the long run?
No, I personally definitely see it as a good thing, because if you have AI taking over from people pretty much everywhere and doing a much better job of it, it leaves us to have, again, almost an unlimited amount of resources, an unlimited amount of invention, and really to have the ability not to necessarily define ourselves through our work. And that wouldn't stop people from being productive. I'm not here to tell you what the meaning of life is outside of work, but Plato thought it was obtaining human knowledge. So maybe we'll all engage in continuous self-improvement. Yes, a machine can beat the world's leading chess player, but I don't judge my own value by whether or not I could beat a machine at chess. I still play chess for fun. I enjoy getting better at chess, and I really don't mind that Deep Blue is out there or was out there. Similarly for creative sort of work, I'm an inventor myself. I have 2 patents. I would not be disappointed if DeepMind cured cancer and invented, permanent health. And I might still enjoy tinkering around with a garage, but really just for fun, right? If an AI could make every possible song and rank order what the best ones would be for me for the rest of my life, I would love having that music. And that wouldn't, for me, diminish the enjoyment of making music by myself. So people will still do things in the future. They just, won't be because they have to. People may focus more on their social relationships, or maybe people will spend all day in virtual reality, and far be it from me to tell someone else how to spend their time.
All right, and I'm seeing one last question that popped up from Reza, so let's take it. What are your thoughts, Ryan, about setting up private insurance companies dedicated to ensure AI-based products for safety and fairness, etc., perhaps initially set up by large AI companies to advance AI?
Definitely something to think about. So I think with AI-based products, probably the best person to be responsible for those harms is the supplier of the product, right? The manufacturers and the retailers. And the reason for that being is they're in the best position to improve product safety, to improve their products, and they can purchase insurance to the extent that they need to spread risk. I think something like an insurance scheme like that works best when you have something like the idea of autonomous AI going out and causing harm where you can't closely tie it back to a manufacturer, but where the social benefits of that dramatically outstrip the costs. So for things like vaccines, these have overwhelming public health benefits. On the other hand, they do sometimes cause negative effects, and manufacturers really aren't allowed to change vaccine formulations. So because we generally accept that there's these unavoidable risks but larger benefits, we all pay taxes on vaccines when we use them. They pay into an insurance fund and they pay out. And if we do get somewhere like that on genuinely autonomous AI, I think that's probably the way to go.
Well, thank you so much for joining us today, Ryan. For those of you who are interested to learn more about AI, robots, and the new laws that we may need, check out Ryan's book, The Reasonable Robot.